Right now, at this very moment, millions of immigrants, green card holders, and visa applicants across the world are asking one urgent question: am I still allowed to enter the United States? The Trump administration has signed new immigration orders. Dozens of countries are now sitting on a restricted list. A visa suspension has been placed on 75 nations. And the panic spreading across social media is causing real people to make dangerous decisions, canceling flights, abandoning visa applications, walking away from opportunities, all based on incomplete, inaccurate, and sometimes completely false information. Before you make any move, before you do anything, watch this video all the way through. Because the actual facts on the ground are very different from what most people have been told. You are watching Global Entry News. This is the information you need. Let's get into it right now. Today, we are covering two official government actions that have directly impacted immigration to the United States in 2026. These are not rumors. These are not political opinions. These are confirmed signed orders issued by the Trump administration and the U.S. State Department. We are going to tell you exactly what these orders say, exactly who they affect, and exactly what steps you need to take based on your specific situation. There are two orders at the center of this story, and understanding both of them clearly is the only way to make informed decisions about your future. The first is the expanded travel ban, which took legal effect on January 1st, 2026. In December of 2025, President Trump signed a presidential proclamation expanding the United States travel ban. This new order extended the list of countries whose nationals now face restrictions on entering the United States and on receiving new U.S. visas. The stated basis for these restrictions, as written directly in the proclamation, is national security and public safety. The countries included were selected through government security assessments, and the order became fully enforceable on the first day of the new year. The second is the immigrant visa suspension issued by the U.S. State Department on January 14, 2026. Separate from the travel ban entirely, the State Department issued a directive ordering U.S. embassies and consulates around the world to immediately pause the issuance of immigrant visas for nationals of 75 countries. This directive is tied to an ongoing policy review of visa screening procedures and what is known as public charge admissibility standards. The suspension is currently active and remains in place until the State Department issues further guidance. These are two completely separate actions. They have separate country lists, they have separate legal foundations, and they affect different categories of travelers and applicants in different ways. Mixing them up or treating them as the same thing is exactly what leads to confusion and panic. So let us walk through each one precisely. The expanded travel ban restricts entry and visa issuance for nationals of designated countries who were outside the United States and who did not hold a valid U.S. visa as of January 1st, 2026. If you are a national of one of those designated countries, if you were outside the U.S. on that date, and if you had no valid American visa in your passport, you are now subject to restrictions. What that means practically is that applying for a new visa will involve enhanced security screening, additional documentation requirements, and in some cases, a complete block on issuance depending on which country you are from. But here is where the misinformation has caused the most damage. And this is the part that Global Entry News wants to make absolutely clear. The travel ban does not apply to people who are already inside the United States. If you are currently living in the U.S. under any lawful status, a work visa, a student visa, a green card, this ban does not touch your presence here. You are not required to leave. Your status has not been altered in any way. The travel ban does not automatically cancel existing valid visas. If you hold a U.S. visa that was issued before January 1st, 2026, that visa is still valid. The government has not canceled existing visa stamps. You can still use a valid visa to enter the United States as long as you meet all standard entry requirements at the port of entry. And critically, the travel ban does not remove green card status. Lawful permanent residents are explicitly exempt from the entry restrictions of the expanded travel ban. A green card holder retains full permanent residency. This order does not change that in any way. Now let us move to the second action, the immigrant visa suspension covering 75 countries, because this one has its own set of consequences that are just as important to understand. On January 14th, 2026, the U.S. State Department directed consular officers worldwide to halt the issuance of new immigrant visas for nationals of those 75 affected countries. An immigrant visa is the category issued to a person who intends to permanently live in the United States. This includes family-based visas, petitions filed by U.S. citizens or green card holders for their spouses, children, and parents, and employment-based visas such as the EB-1, EB-2, and EB-3 categories tied to job offers or extraordinary ability petitions. If you are from one of the 75 affected countries and your immigrant visa case is currently being processed at a U.S. embassy or consulate abroad, your case is on hold. Consular officers have been instructed not to issue immigrant visas to nationals of these countries while the suspension is active. In practical terms, this is what that means. You may still submit applications, you may still have an approved petition sitting on file with USCIS. You may in some cases still attend an interview appointment at your local consulate, but the actual visa, the physical document that allows you to board a plane and arrive in the United States as a new permanent resident, will not be issued while this directive remains in force. However, there is a critical fact here that must not be overlooked. This immigrant visa suspension applies only to immigrant visas, the permanent residency category. It does not apply to non-immigrant visas. Tourist visas in the B1 and B2 categories continue to be processed. Student visas in the F and M categories continue to be processed. Work visas, including the H-1B, continue to operate under standard procedures. If you are applying for a temporary visit, for education, or for certain work purposes, this suspension does not block your non-immigrant visa application. That distinction matters enormously for millions of people who have been told their entire case is frozen when it simply is not. Now let us speak directly to green card holders, because this is where the most fear and the most misinformation is currently spreading. If you are a lawful permanent resident of the United States, here is your legal status as it stands today. Your green card remains valid. No executive order has stripped green card holders of their permanent residency. You continue to have the full legal right to live and work in the United States. You continue to have the right to re-enter the United States after traveling abroad. If you leave the country and wish to return, you are broadly permitted to do so as a green card holder, provided certain conditions are met. You must carry your valid green card, the Form I-551. Your card must not be expired. You must not have been outside the United States for more than 12 consecutive months, because that length of absence can raise serious questions about whether you have abandoned your permanent residency. If your trip was more than 6 months, but under 12 months, carry clear documentation showing your ties to the United States, employment records, a lease agreement, bank statements, tax filings. If you have any prior immigration violations, unresolved legal matters, or criminal history of any kind, do not travel internationally without first consulting a qualified immigration attorney. For green card holders with no complications and valid documentation, the path to re-entry remains open. If you currently hold a valid non-immigrant visa, a tourist visa, a student visa, or a work visa that was issued before January 1st, 2026, your visa has not been canceled. It remains valid for travel and entry. You can use that visa to come to the United States, subject to the standard admissibility review that takes place at the port of entry. Every single person entering the United States goes through inspection by a Customs and Border Protection officer, regardless of what visa they hold. That officer has the legal authority to question your admissibility based on the full picture of your circumstances at the time you arrive. Carry all supporting documents for your travel. Be prepared to state clearly the purpose and duration of your visit. Consistent, complete, and honest documentation is always your strongest protection at the border. If your visa has expired and you need to apply for a new one, the process now involves additional layers depending on your nationality and which country list you fall under. Enhanced security screening is being applied across the board. Processing times are longer. In some cases, visa issuance may be restricted. Reach out to the U.S. Embassy in your country directly for current information on appointment availability and how long processing is currently taking. There is one more policy factor shaping the current immigration environment that is not getting nearly enough attention, and it is called the public charge ground of inadmissibility. Public charge is a long-standing provision of U.S. immigration law. It allows the government to deny a visa or deny entry to someone deemed likely to become primarily dependent on government financial assistance after arriving in the United States. The current administration has placed heightened emphasis on public charge standards throughout the entire visa review process. What this means, practically for applicants, is that consular officers are examining financial documentation far more carefully than before. Proof of stable employment, sufficient income or savings, private health insurance, and overall financial self-sufficiency carries significant weight in visa decisions right now. If you are preparing a visa application, your financial documentation needs to be thorough, current, and clearly organized. Public charge rules do not apply to green card holders returning to the United States after international travel. This standard is directed at new visa applicants being evaluated for their initial admission. Based on everything covered in this video, here are the clear and immediate steps every affected person needs to take. If you are a green card holder, verify right now that your card is valid and not expired. Keep all documentation of your U.S. ties organized and accessible. If you plan to travel internationally, limit the time you spend outside the United States. And if your situation involves any kind of complication, prior violations, long trips, any legal history, consult an immigration attorney before you travel. If you hold a valid non-immigrant visa, your visa remains valid. Carry your full set of supporting documents every time you travel. Be ready for standard inspection at the U.S. border and answer every question honestly and clearly. If you are waiting on an immigrant visa from a U.S. embassy abroad and your country is among the 75 affected by the suspension, contact your immigration attorney immediately. Keep all your underlying documents current. Monitor announcements from the U.S. State Department and your local U.S. Embassy. Do not allow any approved petitions to expire while the suspension is in place. If you are from a travel-banned country and currently have no valid U.S. visa, understand that applying for a new one will involve enhanced review and potentially extended timelines. Seek qualified legal guidance before submitting any application. And for every applicant across every category, strengthen your financial documentation. Public charge scrutiny is real, it is active, and it is shaping outcomes right now. Here is the bottom line. The Trump administration has enacted an expanded travel ban and a separate immigrant visa suspension affecting 75 countries. These are significant policy actions with real consequences for families and workers around the world. But they are not a total shutdown of U.S. immigration. Green card holders retain their status and their right to re-enter. Existing valid visas remain usable. Non-immigrant visa processing continues. What has changed is the level of scrutiny applied, the added restrictions for new applicants from affected countries, and the pause on immigrant visa issuance at U.S. embassies and consulates worldwide. The details of your specific situation are what determine your options. And that is exactly why accurate information and qualified legal advice matter more right now than they have at any point in recent memory. Global Entry News will continue tracking every official update, every policy change, and every development in this story as it unfolds. Our commitment is simple: facts only. No speculation, no panic. Just the verified information you need to protect yourself and your family. If this video gave you clarity today, please like it right now. Subscribe to Global Entry News and turn on notifications so you receive every update the moment it goes live. And if someone you know is worried about their visa or their travel status right now, share this video with them today. Accurate information can make all the difference between a good decision and a devastating one. This is Global Entry News. Thank you for watching. We will see you in the next video.